let's see, I used to be 6 feet. Now I'm like 5'11" and a half.
Okay, yeah, you probably played prop if you were
Yeah,
big and slow. Yeah, that's
big and slow.
yeah.
Okay, well, it is 1:50 now, gentlemen. That was a lovely pre-conversation to set us all up. I love that. So I'm Judith, everyone. I am the EELS president. It's lovely to have you all. Thank you for joining us for the environmental class actions, the good, the bad, and the ugly. We have our 5 panelists. We have our moderator, Professor Bill Goodell, and he is I'll go through everyone's bio, and then we also have Joseph Bruno Sr, Mike Stag, Lou Grossman, and Jimmy Doré. And so to start off with Professor Goodell, he is the owner of the Goodell Law Firm and adjunct professor of law at Tulane Law School. After receiving his BA from the University of New Orleans in literature in 1976, he continued on to law school at LSU, where he received his JD in 1980. Bill also received his LLM in energy and environment from Tulane in 1987, conferred with distinction. Since 1988, Bill has been practicing environmental law exclusively, representing the public interest in property cleanup, pollution control, toxic injury, and natural resource damage / conservation matters in proceedings before the state and federal courts, state and federal environmental agencies, and the Louisiana legislature. Since 1999, Bill has taught various environmental law courses at Tulane. Joe Bruno is a managing partner at Bruno Bruno. He is a defender of class action procedures, seeing them as an important balancing tool in our complex society. He is a graduate of Tulane University and Tulane Law School and is the class of 1978. In 1979, he went into partnership with his father, Frank S. Bruno, a well-known and respected litigator, most particularly in the field of workers' compensation. Mr. Bruno has been admitted into practice in all courts in Louisiana and Texas, as well as the United States District Courts for the Eastern and Middle Districts of Louisiana, the United States Fifth Circuit Court of Appeals, and the United States Tax Court. He is recognized as an authority in class actions, and particularly in class action management. His expertise in difficult and complex litigation has led to his representation of numerous claimants in class action and mass joinder proceedings involving racial discrimination, occupational lung disease, product liability, and wage and hour violations. He has been active in the Louisiana Trial Lawyers Association, having served on the board of governors for over 20 years. We have Lou Grossman. He is a partner in the New Orleans office of Kean Miller and practices in the environmental litigation, energy, and appellate groups. Since being admitted to practice in 2003, he has handled complex disputes involving the energy and petrochemical industries, including toxic tort claims, environmental damage claims, and commercial litigation. In addition, Lou has handled the appeals of numerous high-profile legal issues at the trial and appellate court level. He is listed in Louisiana Super Lawyers as a rising star for 2013 and 2014. Lou was admitted to the Colorado Bar in 2015 and was listed as a rising star in Colorado Super Lawyers in 2016 and 2017. Lou is an AV-rated Martindale Hubbell. And we have Mike Stag with us. He serves as the firm's managing member. He is involved in all practice areas at Stag Liuzza with a particular passion for achieving justice for those who have been harmed by large corporations and oil companies. He has pioneered the field of technologically enhanced natural occurring radioactive material, norm litigation over the years. Over the years, he has recovered awards for more than 300 million in settlement and in excess of 1 billion in jury verdicts for his clients. Mike was recognized in the Lawyers Weekly top 10 jury verdicts of 2001 related to the $1.056 billion verdict, Greffer versus Exxon. He was also an executive committee member for the class action in the Patrick Joseph Turner versus Murphy Oil USA, which resulted in monetary compensation and cleanup settlement valued in excess of $300 million. Prior to his work at Stag Liuzza, Mike worked as a law clerk for the Honorable Ronald J. Scholes at Civil District Court in New Orleans. And currently he focuses in toxic torts, environmental and royalty litigation, as well as harmful pharmaceuticals and defective medical devices. And he has a lot more to say, but I feel like we have a very good rundown of him. I'm sorry.
Yeah, I think you covered it. That sounds great, Judith.
And then we have Jim Doré. He has experience of litigating, negotiating, mediating, and arbitrating cases involving disputes ranging in value from hundreds of millions of dollars to thousands of dollars. A member of the American College of Trial Lawyers, his 45-year practice includes work in personal injury, commercial and business, medical malpractice, environmental, and oil and gas, with a specialty in legacy litigation. He has a unique perspective of having practiced extensively in both the plaintiff and defense bar. After graduating in 1973 from LSU Paul M. Herbert Law Center, he began his plaintiff practice and then became a partner at Kean Miller in 1995, engaging primarily in litigation defense. He retired from the partnership in January 2018. AV preeminent rated lawyer and listed best lawyers in America and Louisiana super lawyers. He attended the Pepperdine Strauss Institute for Dispute Resolution. And that is our panelists.
All right, so I guess it's my turn to take over, and I'm not going to say much other than interject, try and keep things flowing if I have to, which I probably won't. And I guess our first speaker is going to be Joe Bruno. So Joe, have at it, brother.
All right. First, let me apologize in advance because I'm likely to speak quickly. I've been allotted 15 minutes, and there's a lot of ground I want to cover. Two cases I want to describe. First is a case called Johnson versus the city of New Orleans and Hano. And the second case is a case called Gerard versus DuPont and Denka. The Johnson case referred to as the Agriculture Street dump site case. It started in 1994. It is still pending today. It's a 27-year-old case. Essentially what happened was the city had a dump that they wanted to repurpose, so they decided to develop it, build some houses on top of it. They built houses, they built an old age home, and they built a school. What they didn't bother to do was ascertain whether or not there was any toxins below the ground. Of course, there were. In about 1994, 1995, EPA came along and said, you know, this is likely a Superfund site. And can you imagine waking up to get your paper, you walk outside and you see a bunch of guys in moon suits taking soil samples. In any case, it resulted in a class action, which was certified many, many years ago. But unfortunately, the reason why the case is still pending is one cannot recover a judgment against the city or Hano. So we don't have a judgment for each of the individual plaintiffs. We have a judgment for about 60, 65 individual folks. But the reason why the case is important is because first, it deals with toxins, number one. Number two, it deals with the fear or the associated emotional distress that comes from living on top of a bunch of toxins. And of course, the main point or the reason why I talk about it today is because it's pre-CAFA. It's pre-CAFA. The other case is Denka. Denka is a Japanese firm that purchased a piece of a DuPont facility located in Laplace, Louisiana. DuPont, you may or may not know, there is a tie. The original DuPont was in the court of Napoleon, came to this country, opened a explosions factory, and was in the chemical business ever since. Well, these guys make neoprene. Neoprene is a plastic or a rubber which is used in wetsuits and things like that, a lot of car parts, and so on and so forth. One of the ingredients to neoprene is something called chloroprene. Chloroprene is believed to be, and I'm using these words particularly because the EPA calls certain chemicals, they cause cancer, or they're likely to cause cancer, or they're suspected to cause cancer. There's three categories generally. This chemical was recently, 2010, well, it goes back earlier than that, but in any case, EPA finally came out and said this stuff is likely carcinogen in 2010. DuPont, interestingly, when they discovered that EPA was going to make this determination, decided to sell the facility, interestingly enough. So they sold it to the Japanese. The Japanese didn't know, or so they say, that the EPA was going to suggest that they reduce emissions to 0.2 milligrams per cubic meter of air, and so that resulted in some fighting between Denka, LDEQ, with regard to how much of this material they could release into the Laplace area. The problem, of course, was what do we do for the folks in Laplace? Well, the first thing we understood was that anybody who's exposed to chloroprene has sustained an increased excess risk of cancer. Now, cancer is the nasty word, and frankly is practically the reason why Daubert came into existence. I had a slide, but it just take too much time. Just quickly tell you that of all people, Vice President Dan Quayle in 1992 wrote that civil litigation had quadrupled, and there were millions of cases being filed, and therefore we have to do something about it. And that was the beginning of Daubert. And of course, what Daubert is supposed to be a gatekeeping function to prohibit folks from opining about, in particular, whether certain toxins cause cancer or not. So that was the first hurdle that we had to contend with. And of course, along the way, and even up to this day, I would normally say the Republicans, but I'll say corporate America, or the moneyed folks of the world, are working overtime to continue to throw roadblocks in our way. So what can you do today? Can we go back to the first slide, Judith, the 667? Nope, the first slide. There it is. Okay. Referenced Napoleon. You all know 1808, the Code Napoleon, a fabulous piece of work, extraordinary for its time. First time ever, women were given rights. Women owned, they had community property. But to me, one of the most intriguing things that Napoleon did is that he put limitations on wealth. And that limitation basically is this: if you own a piece of property, which means you have to be wealthy, you can't build anything you want on this piece of property. You have limitations. In fact, what you see here, a proprietor may do with his estate whatever he wants to, which, by the way, is what generally happens today. But he cannot make any work which may deprive his neighbor of the liberty of enjoying his own, or which may cause damage to him. So what we have here in reality is a limitation of what, I hate to say it, what rich people can do with their money. You can do a lot, but you cannot deprive your neighbor of the enjoyment of their property. So this, in my mind, is the new basis for toxic tort in Louisiana. Next slide, please. Couple of good cases for you to look at, to learn more about it. Collette versus Weyerhaeuser, very good case. Judge Fallon wrote it, basically talks about the fact that what this really is a legal servitude. I know I'm using a lot of civilian terms. I don't know how many of you guys are on the common law side, but essentially it's an obligation that's created by virtue of the nature of what they're doing on their property. The next slide, please. Judith? Great law review article called Burying Caesar. It came out just about the same time that the amendment to 667 was done. Essentially what they did in 1995, 1996, the legislature, again, in an attempt to narrow the rights of individuals to recover for these kinds of things, put a requirement that you had to demonstrate that the offending property owner knew or should have known that that whatever it was that they were doing was likely to cause damage or likely to interfere with the enjoyment of a person's property. So they introduce essentially a negligence component to the whole thing. Next slide. Now, so we have the basis, we have the cause of action, if you will, against, oh, I'm sorry, I want to mention this too. The other reason why I thought this was very interesting is did some research on the internet and found several articles by the big law firms who are publishing these pieces, obviously to let industry know that they do these kinds of things. But what they're saying is that they believe that toxic trespass is the next big wave of litigation, and that you're going to find there are many, many articles on this subject all over the place. Now, of course, in the common law states, they regard this as trespass or possibly nuisance, but the concept is the same. Next slide, please. Just another example of a slide. Next slide, please. I mean, of the article. All right, so get to class action. So what do we do with this problem we have? We have lots of folks, and we want to do some good for them. So back in the day, we would simply file a class action. Well, no more. Now, why, Joe, do you say no more? I mean, all CAFA does is give federal jurisdiction or creates federal jurisdiction over basically all class actions. Well, here's the problem. The problem is that in the Fifth Circuit, this circuit will not, I repeat, will not certify any class action where the basis of the claim is personal injury. You will, at least our experience has been, Mike will speak to this in a moment, we filed a class action against Murphy Oil after Hurricane Katrina. It was property damage. It was certified and settled in that fashion. But if you try to bring a class action now in federal court, you're never going to get certified. So if you can't get certified, what do you do? So quickly, CAFA gives federal jurisdiction generally if you have a class action, even if you don't have complete diversity. There is, next slide, please. There is an exception. And the exception is that if greater than 2/3 of the class are citizens of the state, and one of the defendants or one of the principal defendants is also a citizen of the state, then there is no CAFA jurisdiction. And frankly, we were able to do this in another case, but in our Denka case was not going to be possible because obviously DuPont, Denka are foreign corporations. Everybody is local, fine, but they were going to be removed. So what we decided to do was we filed, in connection with individually filed claims, an affidavit from each plaintiff certifying that the value of their claim was less than $50,000. Why $50,000? Obviously, first, we wanted to go below the $75,000 jurisdictional limit. And secondly, we wanted to avoid a jury trial. Of course, that has been changed recently as well, down to 10. Again, another effort by the guys on the other side to make life far more difficult for us than it really needs to be. And by the way, you citizens out there, because you got more jury duty. Next slide. Next slide, please. Next slide, please. All right, so our case was removed and we were remanded. Of all people, Judge Feldman found that because each individual plaintiff had a claim that didn't meet the jurisdictional requirement, sent us back to state court. So we're good there. We're now in state court. Next problem is, well, how do we prove the claim? What are we talking about? Well, there's a great article I commend to everybody in ProPublica. It was published on November 2, 2021. It's entitled "The Most Detailed Map of Cancer-Causing Industrial Air Pollution in the United States of America." And just to give you a sense of what they've done here is, the average risk of cancer in this country is 1 in 33,000. The average risk for folks who live in Cancer Alley is 1 in 210, which is 47 times EPA's acceptable risk limit. As I told you, chloroprene is a unique chemical, is manufactured in only one facility in the entire United States. Therefore, our logic was that they're not going to be able to do what they normally do, and that is, well, your exposure's been confounded by the benzene, the toluenes, and all the other stuff that's in Cancer Alley. This way, we focus only on chloroprene. Doesn't matter if you smoke, doesn't matter if what your medical condition is, doesn't matter, nothing matters. Because what the experts are able to do is they're able to evaluate with a number, the excess risk of cancer to you resulting from your exposure to chloroprene while you lived in that area. So we have an actual tangible injury. We have this excess risk. I'd also point out to you that Louisiana law is unique. I had the great fortune of having been taught by Professor Stone at Tulane Law School, who wrote a brilliant treatise on tort law. And we are I think we are the only state which has really no threshold with regard to injury. In other words, you are entitled to be paid compensation for any injury to you, however slight. So there's no measurement, there's no threshold that's required. So if you put 2315 together with 667, you have an actionable injury. So where we are now is we are in the process of trying to determine how to move forward with trials, because we have 6,000 individuals. It's a mass joinder, as I pointed out to you. And of course, the first thing the other side wants to do is they want to require each of these 6,000 people to respond to discovery. And because why? Because they want to make us spend a bunch of money. I would commend to you very important, and my time's up, but let me just talk about this one article. I think it's critical. It is a Louisiana Code of Civil Procedure article. Can we move a couple of slides ahead? Okay. Code of Civil Procedure Article 1420B says the signature of an attorney or party constitutes a certification by him that he has read the request, response, or objection. This is discovery, and that to the best of his knowledge, information and belief formed after reasonable inquiry of the request, response, or objection is, and this is the key, not unreasonable, unduly burdensome, or expensive. Here's the key: given the needs of the case, the discovery already had, the amount in controversy, and the importance of the issues at stake in litigation. So in other words, what you can't do what they normally do, take an 8-hour deposition on a case where you're not really suing for a whole bunch of money. So with these ideas, I mean, I feel like a hobo making my soup with shoes and socks, but the nature of what we do is as they continue to reduce the opportunities that we have for recovery, we have to get more creative, and we use the devices that are in place. Last piece is that in the Johnson case, the judge did a brilliant thing. That is the dump site case. Rather than require a trial for each individual plaintiff, the judge simply said, hey, look, each person who lived on the site should be paid $1,000 per year for each year that they lived there, which gets you around the notion that you have to have individual trials. It's another game the other side wants to play, because they think you have to have a full-blown trial for each individual emotional distress case, no matter how small, no matter how little money you're requesting. So I will stop to allow my other panelists to speak.
Thank you. Great. I have some follow-up questions, but we're going to save it to the end in case nobody in the audience does. I guess our next presenter will be Mike Stagg to talk about his class action experiences. So go ahead, Mike.
All right. Thanks, Bill. Hello, everybody. The good, the bad, and the ugly of environmental class actions. There's a lot there. So let me just kind of talk a little bit about, most of my conversation will be about, I think under Federal Rule of Civil Procedure, Article 23, or, Rule 23, because, most of your environmental class actions these days will end up in federal court, unless you're, like Joe was saying, able to, beat CAFA. Been doing these cases a long time. had some that have worked out, have had some that did not work out. Generally speaking, I think environmental litigation and class actions make sense, especially when you have large disasters like the BP oil spill. Joe mentioned the Murphy oil class action. Joe and I worked together on that case. For those of you who don't remember that one, it's Katrina hits. Murphy oil had a storage tank of oil. It wasn't properly prepared for the storm. The tank floats, crude oil comes out. Murphy oil refinery is right next to a bedroom community, subdivision, and crude oil goes all over and pollutes the neighborhood. And right now I'm working on a class action related to another hurricane, which was Hurricane Harvey in Houston, where the Arkema chemical facility flooded, and they had this similar situation where they lost refrigeration. They manufacture peroxides, which must be kept at a very cool temperature, or else they tend to explode, causing they cause you have a chemical reaction, violent chemical reaction, and they were not properly prepared. They didn't get the chemicals off site. They didn't have backup power. Their generators were in a floodplain below where the water levels were, so they lost power, and it caused a mass fire and explosion and pollutants to go out into the environment. Now, one of the reasons I think that class actions work for environmental cases when you have large disasters like this is that you can do a lot for a broad area. Typically, when you are going forward with class certification, one of the things you got to show is that how do you define the class? And typically the way you're doing that is to draw a line around the affected area. Where did the pollutants get? Where did the constituents of concern go? In Murphy oil, there was testing around the neighborhood to get the full extent of where the oil went, because the flood waters transported the crude oil out into the environment. And as the flood waters receded, the oil was deposited into homes, into yards, into areas. And of course, the oil company's defense to that is, well, how do I know that oil is not from someone changing the oil in their car? Or how do I know it's not from the gas station down the street? And so we hired an expert who did fingerprinting and fingerprinted the oil so that he could match the chemical signature of the crude oil that was at Murphy oil with the crude oil that we were testing and finding around the neighborhoods. And through that, and also with some EPA data we collected, we were able to basically draw a line around the Murphy oil plant. And so that's the way we did it there. In the Arkema case, which was somewhat similar in the sense that you had a plant, you had a hurricane flooding that caused the plant to have a problem and caused pollutants to go out into, again, the neighborhoods, farming area, other people damaging other people's property. Essentially, you did the same thing, except for the fact that this was actually a flood. And I'm going to go, I'm sorry, a fire that was caused by the flood. I'm going to go ahead and share a screen, and I'll show you. This is the Arkema plant. And this is the fire that resulted, and you can see a plume coming off from the fire. And what we did was, and this is a more close up of the fire. And what you have in this fire are various chemicals, because you have a lot burning up in here. Whenever you have a fire, oftentimes you're gonna have dioxins, which is a known carcinogen. Also, there were some other chemicals that were unique to the containers that these chemicals were contained in, and also some other chemicals that related to, the type of the peroxides. And once they burned, they produced other different types of chemicals. And what you have is a large plume that goes up in the air. The fire lasted for many days, and And then what you end up doing is you need to go out and do some testing. So what happened was you go around the neighborhood and you look and there's ash falling out of the sky. And this ash is all over the place around the areas. And in this ash are these various toxic materials. And of course, as it rains, as the wind blows, the material gets, broken up and it's absorbed into the soil and surrounding soil. And therefore you need to test and identify where it is and then clean it up. And you have experts who go out, perform testing, analyze the tests, and do some comparison from some sampling on site and off site. So like in Murphy, where you could fingerprint the oil, here you're fingerprinting certain signature chemicals and trying to determine, are these the same chemicals that were on the site where the fire took place that are now out on my client's properties miles away from the facility. And this is an example of the fly ash fingerprinting of the off-site grass samples versus the Arkema dust samples. And here you can see the chemical analysis is virtually identical. And you have an expert who testifies about that. Now, the other thing you want to do is to draw your line. And this is a, can everybody see this? Can you all see this? I'm just making sure you can see my screen.
No, Mike, I didn't realize I think you swapped your slideshow after the first picture.
Oh, okay. Well, all right, hang on a sec. Let me get back to where it was. All right. All right, this is, can you see this now?
Yes.
Okay, great. What we're looking at is an overview with the Arkema plant site in the center. And this is an air model. And when you draw the line around your class to determine, who's going to be within the class, one of the things you do is you hire an air modeler in this instance to try to run these programs that determine, based on these fires, how high the plume went up, what the weather patterns were, where the wind was on various days, identifying where the chemicals would have blown. And this one was one of the nice things about this was not an expert that we hired. This was an expert that was hired by the Texas Commission of Environmental Quality and performed air modeling for that agency. So we were able to use some of this data to help support what we were saying with our on-ground sampling. And we were seeking to do a class action that was 7 miles out and would have covered 35,000 people and a lot of property owners. And this basically models, what the maximum impact was for various contaminants within these various areas. And these lines you see are called isoplex, which outline the extent of where there was chemical disposition through the air. Now, we also did some other air modeling as well that we did on our own, which did some disposition of it related to it, and showed where the chemicals fell out. And so let me try to stop my share here. So that's essentially what you try to do to draw the line around the class. Now, one of the things that I think is really helpful in the class context in these environmental claims, and one of the things I always try to advocate for, if I can, is that it makes sense to perform a cleanup of these properties in a class context rather than on an individualized basis. And part of the reason is that you can have migration of chemicals through air, wind, water, et cetera, that goes on for years. So, if I have a property that's been contaminated and I spend a lot of money to clean it up, but my neighbor doesn't, well, those chemicals from my neighbors can persist, and then they can, come back onto my property. So one of the arguments that we tend to make as a basis for certifying the class is that the class actually helps to resolve a global problem, and to do this piecemeal doesn't make sense. I also, I think Joe and a lot of the other panelists may agree with this. Class actions, because of the requirement that you almost really have to prove your case at class certification level to some extent, based on a lot of the Supreme Court rulings. It really comes down to class certification is everything in these cases. Oftentimes the cases rise or fall on class certification. If you wins class certification, then usually that prompts the defendant to start talking about resolution of the case, like you did in Murphy or in the BP oil case, as opposed to going to trial. That's not always, but I think there's a better chance that if you succeed in class certification, that you can resolve the case, because the defendants know how big that case is, and it increases the risk for them. And you've got a large damage case that they need to deal with. There also are, if you are unsuccessful in succeeding on your class certification, there are other methods in which you can, bring mass actions. And I think Joe was describing what, would be a mass joinder or a mass consolidation of claims. And that's usually like a backup, that I usually take. For example, in the Arkema case, if we're not successful in class certification, we were able to sign up around 900 different property owners. So the case makes sense that we could, on an individualized basis, go forward with 900 property owners to try to resolve their issues on an individualized basis through a mass action. And so those are some of the ways that, those are some of the topics in environmental class actions. I don't think that, I could cover everything within 15 minutes, but, I think that pretty much covers, some of the bigger issues that I see, related to environmental class actions, at least early on at the onset. Now, I also saw you were curious about how you, maybe you get clients or how people come to you. And I saw that as one of the questions that Judith put in this. Oftentimes when you have a big incident like this, people are very concerned. So if you, usually we work with local lawyers there, attorneys that are in the community that we have relationships with. Oftentimes they have deep roots there, and they have a lot of existing clients there, and they know people, and people are coming to them, but they don't have necessarily class action experience or experience doing big mass torts. And through relationships, usually that's how we develop. We go space, assured, a space and get a national meeting, just to tell people this is what we're doing. These are some of the issues that are out there, and just as a public service, tell folks don't have legal representation at the time they're signing off their rights, and so sometimes it's important to inform them, as to that. So I'll be happy to answer any questions when we get to the question and answer session. And thank you for having me.
Yeah, thanks, Mike. As a footnote, I remember the class action involving the Gaylord chemical plant in Bogalusa. They came out after that with very strict standards about, and they may no longer be in effect, about solicitation of clients, because lawyers were setting up Winnebagos at the plant boundary. At least that's what I heard. I'm assuming it was true, but I don't know that from firsthand knowledge to sign up people.
It's true,
and
Bill,
so-
unfortunately.
Okay,
Yeah.
yeah, all right. I thought it was.
Yeah.
All right, thanks.
And actually in Texas, it's even stricter. It's actually a crime for a lawyer to solicit. So you have to
Lou Grossman from the defense bar. And I will say that I've litigated a couple of cases with Lou, and I had the utmost respect for him as a lawyer and as well as a human being. He's not he's real and he talks to you, and we've had some very frank discussions over the years. So Lou, if you could share your thoughts and insights.
Absolutely, and thanks, Bill, for that. Can everybody hear me? Can you all hear me?
Yeah, I can hear you. Yeah.
Good. Just want to make sure, as I said earlier, I had to rig this up through my phone instead of my computer. So I'm going to take a step back a little bit here with what I'm talking about. Both Mike and Joe have given more of a granular set of information for everybody to consider. And I'm going to talk kind of bigger picture on the defense side about how we go about defending actions and what we do to advise our clients. Importantly, I think before a class action is even filed is to keep your finger on the pulse. In the environmental context, most of the class actions really do follow a large and specific event, whether it's a train car derailment, an oil spill, chemical plant fire, or explosion. Others have less conspicuous origins. So it's important as defense counsel to keep your finger on the pulse. And one way we do that is by monitoring what I like to call litigation chatter. And when I say that, I refer to not just, I guess the most ubiquitous form is advertisements from the plaintiff's bar and others, where the public is advised, if you took this kind of drug, you may be entitled to compensation. But Joe referred to some articles about toxic nuisance and understanding what the plaintiff's bar is doing, understanding what the regulatory agencies are looking at, what state attorneys general are looking at. That's going to help you to prepare your client that, hey, there might be a class action on this particular issue coming down the line. Once a class action is filed, I think everybody on this call would agree that class litigation is inherently uncertain. And in my 18 years of experience, I don't know that I have been involved in litigation that has any less clarity about the potential liabilities, the size and scope of the class, the types and the amounts of damages that are involved, the evidentiary issues, the choice of law issues. And so this makes it very difficult and challenging to decide the best course of action early on in litigation. But nonetheless, what I'm going to talk about are some basic tips that some of it may sound rudimentary, but will help us as defense counsel look at a claim and understand maybe how to defend it early on and make a preliminary decision for our clients or with our clients. And the first thing I would say is to know all of the facts and know the law, because early case assessment is critical in class litigation. We've got to go beyond what the complaint or the petition says and really do your own independent fact investigation with the client and externally. Hearing Mike talk about the Arkema fire, it's clear that, listen to Joe talk about the Agricultural Street lawsuit. These guys know the facts very well. And it's important for them, but it's also important on the defense side to really get granular and understand what you're dealing with, what was the event, what caused it, how widespread are the impacts, and importantly, really identify what information gaps there are. What do you not know? What does the client need to know? What does the client not know? And factual investigation can and should, to some extent, focus on what individual factual issues you can use later to challenge class certification. It's important to hire experts early on. We heard Mike talking about the Murphy oil spill and how experts were hired to do fingerprinting analysis on the oil. These are all things that are going to help you from a preliminary stage of understanding what the end game should be. Another part of this is to determine early on whether there are challenges that you can bring with respect to the claims that are specifically asserted. Are there claims in the petition or in the complaint that don't really have a basis in law? And are there, for example, retroactivity arguments you can make? Does the plaintiff has standing to assert claims under a particular environmental statute? Are there challenges that you can do at the front end, whether it be through Rule 12 motions, exceptions, or early summary judgment motions, to narrow the scope of the litigation? This is all part of understanding the facts and understanding the law beyond the scope of what's in the petition. Equally important, I think, is to know who the players are and to know your jurisdiction. Bill mentioned that he and I have worked together. I've actually had occasion to work with Mike Stag on a few cases. Knowing your opposing counsel, really, and developing a relationship with your opposing counsel, one of mutual respect and as much trust as plaintiffs and defense lawyers can have, will go a great way to helping you manage what would otherwise be a kind of crisis level event for the client. Understanding who your judge is. What dispositive motions will this judge consider early on? Or will the judge consider any early on? And knowing your jurisdiction, one of the things that we talk about in the defense bar are magnet jurisdictions. I've heard them referred to as judicial hellholes. I don't really like that terminology myself. But are there ways that you can get out of a particular jurisdiction because you know you're unlikely to get a favorable jury pool, or you're unlikely to get a favorable ruling from the judge? And again, factually, there may be a basis to do that. You just have to understand early on. The next big part of this, in my mind, is you really want to develop a comprehensive game plan to mitigate risk to the client. Are there strategies you can employ early on to minimize class exposure, whether it's from a damage perspective or from a class certification perspective? Mike talked about the Murphy oil spill, and I did some work for Murphy in that case. And one of the things that Murphy did that was a good preliminary defense strategy was it implemented a claims process. It set up tents right out there with State Farm and Allstate and the FEMA tents. Murphy Oil had a tent right there in those neighborhoods. So the neighbors could come up, tell Murphy, this is where I live, this is how much oil I had in my house, and Murphy would write them a check. Murphy, in this case in particular, would write checks faster than the insurance companies would. And many of those individual checks turned out to be a little bit higher than what class members got in the class settlement. But this had a twofold effect. One, it reduced the number of individual claimants so that the numerosity component necessary for class certification wasn't necessarily there. It also helped to develop what individual issues we could show with respect to damages. It's a property damage case, not a personal injury case. In personal injury cases, we heard Joe say the Fifth Circuit really doesn't certify those, and that's right. And the reason is it's highly individual how a particular constituent can affect an individual human. Settling these Murphy claims allowed us to develop some of those unique issues with respect to the houses in the neighborhood. Are there some that are on a slab? Are there some that are raised? How much oil did a particular house get? Were they out of their house for longer or less time than others? So developing that game plan early on, it's very important. And as part of that, we really need to advise and work with our clients to understand what is victory in this case and what is the end point of this class litigation. Do you have a client, for example, who wants to put up a fight for everything and take a principled stance that we're not settling anything? Or do you want a client that has broader business objectives and wants to resolve these claims and avoid prolonged litigation that attracts a lot of media attention? So understanding and defining the client's goals, helps you early on to determine whether this is something that you want to fight or not. And if you want to settle it, what's the best course of action to get a quick and fair settlement that is not going to continuously bleed your client. As part of this, you also want to create a litigation theme or a story and develop your facts to support that litigation theme and story. Folks on this case have all, or on this call, have all tried a number of cases and understand that short, simple stories and themes work well with juries. As you are defending a class litigation, it is no different. And you have to treat even the certification stage as a trial. And I'll talk about that in a little bit. But that's, again, developing your facts to support the story you want to tell to the jury is important. Understanding what the risks are is probably the hardest part. And really, this is not just from the damage perspective, but are you going to have a type of class action that could lead to a flood of individual lawsuits if certification is defeated? Are individual suits better than class treatment? You really want to have that scope of possibilities identified and use that to advise your client. Shifting gears a little bit, discovery in the class context can be a little bit more complicated and can be exponentially broader and more expensive in the class context. So early on, understand your client's document management systems. Issue your litigation holds as early as possible, and when necessary, retain discovery vendors and start collecting information. It's equally important to work with opposing counsel to start limiting the scope of discovery. Focus on what is needed, for example, in the certification phase versus what might be needed in a merits-based phase. And this works in both contexts. You may not take a full-blown plaintiff's deposition, but you may take plaintiff's depositions that focus on issues that you think are going to be critical to the certification stage. I talked a little bit about this, but early dismissals, again, class actions, I have never seen a class action complaint that just focused on one legal theory and one element of damages. They are complex, evolving lawsuits. They involve multiple defendants, usually not just one actor. You may represent a client who had very little to do with causing the issue that is giving rise to the lawsuit. So if you look at these things early on, you can eliminate the types of legal theories that the law won't support, the types of damages that the law won't support. One of the big fights that I think continues to happen in Louisiana courts is the availability of damages for fear or increased risk of harm without some kind of allegation or proof that there has been a substantive injury that has occurred. So getting these issues sorted out as early as you can to effectively eliminate or limit the scope of the class action and hence the total risk involved is pretty important. Next, you really want to get to the core issue, which is class treatment appropriate? Will the law support class treatment? If your client has decided that it wants to fight class certification, and sometimes you don't, sometimes you agree that class certification is important in part for settlement, and I know Jim's going to talk a little bit more about that, but you want to demonstrate essentially that individual issues predominate, that you cannot effectively handle this as a class because there are too many individual issues among the plaintiffs, and therefore it would be unfair to some to treat them all collectively. As we've discussed, personal injury claims are usually not good candidates because individual injuries almost always are way too individualized and individual issues predominate. Selection of class representatives for the discovery purposes and for the class certification hearing, this is a two-sided process in my experience, and usually everyone gets to pick plaintiffs both for the discovery purposes as well as for the class certification hearing to highlight on the defense side that individual issues are outweigh any class or collective issues. On the defense side, in personal injury context or other, you try to find those without the most serious damages, or you try to find class representatives that may not effectively represent the interests of the entire class for one reason or another. And finally, treating the class certification proceeding as a make or break point in litigation or as a full-blown trial. I heard Mike say the class certification is essentially a trial on the merits these days because of how much discovery and how much goes into them. And I think we should all, on the defense and plaintiff side, treat the class certification process as though it is a full-blown trial. We have to have our themes, we have to have our evidence, we have to have our witnesses, and really be prepared. Public relations, I'll just say very quickly that there is a PR battle that we're all going to have to fight at some point. Now, not all class actions invite media attention, but some certainly do. So it's important to get a public relations plan in place. As outside counsel, that's not necessarily our job, but it is something that we should advise our clients to get serious about. Last but not least, we should not forget that we need to be creative and collaborative in the defense of class litigation, as we are with all. I apologize if I spoke too quickly or if I took too long, but those are some of my high-level thoughts, really at a mile-high level of how to treat class actions.
Excellent. I think you've got a future as a teacher if you ever get tired of the litigation arena, if you will.
Okay.
Thanks a lot, Lou. That was really good.
Great.
Next, we have Jim Doré, who, Jim's been around for a long time, and he's been involved in just about everything in Louisiana that's environmental in one level or another. But nevertheless, go ahead, Jimmy. Why don't you share your thoughts and insights, please?
Very good. Thank you, Bill. And I'm glad to be here with everyone, and listening to the other speakers always is informative. I've always said I get something out of any seminar that I go to, whatever it's about, because there's people there that know a whole lot more than I do and are able to impart it at least in such a way that you can actually understand it. And they have done that. For my personal practice, when I was practicing law itself, I litigated several class actions over the years. What they've described is essentially it. And what, if you haven't picked up anything else, what hopefully you picked up is that they are extremely difficult and complex cases, as I think all of them have pointed out. What this leads to when you're dealing with this is, I mean, there's jurisdictional issues, federal and state. You're going to have to look at the number of plaintiffs. You're going to have to look at the claims that the plaintiffs have. You're going to have to be able to make a determination of, do you want to, at any point, discuss settlement, and or in my case, I'm going to talk about mediation. And so there are a lot of issues that you're going to deal with. And mediation, by the way, I'm not sure about the experience that everyone that's watching has, but mediation is a non-litigation method to try to resolve that litigation that you're involved in, or even if it's not in litigation before that, in order to allow the parties themselves the hopeful ability to be able to deal with this litigation, if you will, without going to trial. At trial, it's a great risk, as they've described. You can win or you can lose. When you mediate, you've got some control over how that's going to end up and what you're going to discuss. So I think that's the part that does it. The issue that I want to discuss is, well, at what point would you say, let's see if we can settle this, and in particular, let's do it by mediation. Mediation is a non-binding effort on the part of the parties with an objective third party mediator to be able to hopefully resolve the issues short of going to trial and avoid the incredible expense. And I think all of them, particularly the plaintiff's lawyers, will tell you how expensive this can be. Not just for them, of course, it's expensive for the defendants too, but very often defendants have the ability to be able to do that, as I think Joe pointed out, in terms of having the wherewithal, monetarily at least, to deal with it. But I think, you're going to look at this in a way that first you do, I believe, the ones that I've dealt with and the settlements that I've negotiated, we always had the class certification resolved. Because if you don't have that resolved, or if you haven't at least agreed on it in some general fashion between yourselves as parties, then you're going to have the certification in order to make the determination of who's in this class, who's out, and what do you have to do, what are the kind of claims that are going to be resolved, and so on. So, and geographical areas, all the things that go along with what they've cited so far. So it's got to be right, if you will, for that kind of discussion to go sit down and say, okay, let's talk about actual money. And that's what you do. It's truly what someone is asking for versus what someone is willing to pay, based upon what they see this case being about. And the more, that may also require lots of discovery before that time, that dispositive motions, because defendants, I assure you, at least in my experience, I filed any dispositive motion I could think of that may very well resolve some of the issues involved, if not the case altogether. And so you've got to get to that point that now we know pretty much where we are, we know what we're going to be dealing with. So let's talk about whether we can settle it. And I think most parties in all these litigations do, if they can, want to settle it. One of the important parts of that, of course, is selecting a mediator that has sufficient knowledge, both of the case law and applicable law to the case actually they're dealing with, along with some experience, hopefully, in specifically environmental claims or whatever the nature of the case might be. So you want somebody that can do that. And it has to be, I found out as a mediator, as opposed to a litigator, and let me assure you, it's different. It's hard not being an advocate when you've done it for so long, but you have to be a non-advocate. You have to be completely and totally impartial. You have to be able to persevere. Some of these things, we can go to a mediation for a day and sometimes resolve it and sometimes not, or some of these take months. I will stay involved in some cases that have been being mediated over the extent of maybe a couple of months, 2-3 months or so, and sometimes even longer, in order to be able to resolve it, because the parties, again, go find out more things about the case, and they say, well, now we're in a posture to be able to do this, so let's see if we can talk about it. So it can take days or months. Class action, well, first of all, as we pointed out, class actions themselves have many moving parts. The mediation is the same way. Mediation has many moving parts, and courts prefer, at least in my experience, and I think most of the people here would agree, courts prefer to have a third party, a mediator, sometimes a special master, they call it, to be able to go to talk with the parties, discuss with the parties, sit down and hopefully resolve this. Courts or judges are loath to have to do this themselves, and they seldom do that. They do like to have that objective third party trying to encourage and guide people to a point that they feel like they can settle it. One thing about mediation that I think that I've liked is it is certainly more informal than an actual trial by any stretch of the imagination, and for that matter, even arbitration, because arbitration, at least in my litigating experience, is basically just like a trial in many respects. So mediation allows you to, first of all, if you're able to settle, save a whole lot of money. And what you've done is you've allowed your client to be able to look at this in such a way that they hopefully can, after you've discussed it with them, of course, be able to make a decision that, and they say, a good compromise is nobody's happy. I don't necessarily believe that. And I think in my experience, it's not necessarily true either. But you want to be able to prepare your client, and how you prepare him is very important. And as a mediator, I found this out particularly, that if you create expectations in a client, either way, this is a great case, we're gonna get bazillions of dollars, or hey, we got a great defense, they're never gonna win this, et cetera. Those are kind of things that I think you've created now with your client. When you go in and say, okay, we're gonna accept, $1 million or whatever it would be, and all of a sudden they say, wait a minute, I thought it was worth 100 million or whatever you might have discussed before. So you have to be, to me, particularly in a mediation, be careful how you prep your client about those expectations and what they can do. it is non-binding, which means this is going to be discussed. We're going to go back and forth. And I always tell people, okay, I go in, and generally this is done with caucuses, we call them, plaintiffs in one room, defendants in another, maybe several defendants. And so you have several rooms. And so a mediator will go to each room, go to the plaintiff. Then after that, after the plaintiff gives maybe his figure for potential settlement, he gives goes to the defendant and says, okay, this is what the plaintiff discussed. They're willing to accept X or Y and so on. So you go through that. Sometimes I go in that room and I say, okay, I told you this is a process. You can't take one expression of either settlement or otherwise and take it to heart and say, well, I'm leaving, because you'll give them a figure, say, well, they want $1 million. $1 million, that's ridiculous. This is not going to work at all. Although you come back with the defendant's offer, and it's the plaintiffs will get extremely upset because that they're not taking it seriously. And so people talk about, well, we're going to leave. No, don't leave. This is going to take a while. So let's talk about it first before you decide to leave. So those are the kind of things that you want to make sure, particularly in a class action, because you have a class rep or several class reps, and that class rep is going to be the one that is going to ultimately make a decision. They don't go to, if there's 1,000 class members or more, 7,000 class members, then you can't go to each one. That's why you have the rep. And so the lawyers and those reps are going to decide. And you want to make sure that they are able to understand what's going on. And as a mediator, I will, at any time, particularly when counsel will ask me, can you talk to them about how this works or that works or whatever the part of this is, that's what you want to make sure they understand so they feel comfortable making the decisions. But the non-binding part, and it's confidential, of course, nobody can use this for any purposes anywhere else, not in court or otherwise. And I, as a mediator, cannot be called on to testify about what went on, what offers went back and forth, what somebody may have agreed to accept at that point in time and the other would not, or whatever. Those are the kind of things that you cannot ever repeat. And I say that there are extenuating special circumstances that I've never seen actually happen, that in fact that may be able to done, but it's never occurred, at least in my experience. And all of the things that we go through as a mediator for purposes of trying to get in a class concept, at least, the parties to understand and agree and hopefully be able to resolve it. The number of people in the class, what's at stake for each of those. You know, people, $1,000 a person 100 people may feel differently about that than 5,000 people. And so those are the kind of things that I think both between counsel and mediator, we can talk about and explain to them, this is what it is. Each claim, and they have different classes of claims in class actions often. That is, you have more serious claims, you have property claims or personal injury claims or whatever they might be. So not everyone is in the same class. And so each, you have to know and understand what each of those classifications have at stake and be able to talk with them about what it is that we're going to do. I do believe that it's important, and I can't say it enough, to understand that this is a process that takes place over some period of time. Again, it could be a day, or it could be a lot longer. And the other thing that goes on is that the courts are going to have to approve the settlement. And these lawyers can tell you, you go to court with a settlement that you've resolved in a mediation or otherwise, and you go to the court and say, Your Honor, this is what we want to do. And for whatever reason, most courts will say, thank you very much. I appreciate what you did. I agree with the settlement, move forward. And it doesn't end there. The other part of this is those parties have to now come up with a settlement document. And I can tell you from personal experience, and I know all these gentlemen have done the same thing, coming up with that settlement agreement is extremely difficult. You have to outline everything that's going to be done. And if it's going to be a distribution over 1,000 or a lot of people, then you have to decide how you're going to decide what the claims are. There are mediators, and I think it's important to have someone, an objective third party, do that to make a determination when they submit a claim, that this claim fits in this category, this claim fits in that category, or this claim is not worth anything. But those are the kind of things that have to go into a mediation agreement. And so, when you talk about that, it takes a long, involved, a serious discussion among the parties to come up with that agreement. And I've seen them be 30, 40 pages long. And it's got every issue that you have going to have to decide before people get money or money is distributed or so on. So, once the court approves it, it's not over. And you do have to come up with that agreement to be able to present it to the court and tell them this is what you're going to do. And I will tell you, my class action experience was on the defense side, like Lou, and what defendants are looking for, and Joe, when we were talking the other day, he pointed this out, they want absolution. They want this thing over with. They don't want to have to worry about somebody sitting out there that's going to come back and say, wait a minute, I wasn't there. And so that's why it's important. You have the class, you can opt out of it. You have opt-outs. You have objections to the certification. You have all kinds of ways people can come in and try to set aside something that has been done. And so defendants, at least in the end, okay, we've agreed to pay X. This is what we're going to do. But I want to make sure that we have not excluded anybody that's going to come back to us and seek more compensation. And so those are the kind of things that I think the defense side, at least particularly, is looking for, and quite frankly, the plaintiffs want to give it to them. I mean, there's no reason if you represent the class in a particular action, when you say I represent the class, that's what you want. You want to represent everybody that's there, because that means such and much better for the actual class members and counsel himself, and of course for the defense side, it means I'm going to get rid of all this. So I think those, and I apologize for speaking fast. That's just normal for me, particularly in a presentation experience, whether in court or doing this. But I hope it gives you an idea of mediating a case. I will tell you is infinitely better than, and a lot less expensive than going to trial and trying to resolve this thing with either a judge making a decision or a jury. You don't know, I don't care what anybody says, nobody knows what the end result will be in that regard. And in a mediation, you do have some input and some way to control how that may end up. Thank you very much.
Excellent insights, Jim Doré. Thank you so much. We got time for a couple of questions, but I've got a note that the instructions for getting CLE credit, we want to give that out now before the session ends, and people are trying to figure out what to do. So we have Alex Kaiser going to, I guess, put something up or say something, Alex.
Yes. Hi, everyone. Thank you for coming this afternoon. I'm going to release the CLE poll in a second. The code word for this panel is orange. So please click the appropriate answer once it's up. And co-hosts, I ask that you don't click the red end poll button that will pop up for you, because it'll close it for everyone and then people might not get the chance to respond. But I'll close it when it's ready. Thank you. Okay, here's the poll, and the code word for this panel is orange. Please select the correct answer. Okay, you can continue on. I'll just leave it up for a few more seconds so everyone gets the chance. But thank you.
Sure. So the question I had from I won't. Oh, I'll give that name. Miss Haley Gentry. I thought it was a very, very good question, and I'm going to read her question, and it's right along something that I was thinking, but she laid it out pretty thoroughly. How do you view the role of administrative advocacy and other avenues as a complement to class actions? For example, because monetary damages and settlement funds are often the result from class actions, what else must be done outside the courtroom to ensure greater protection for affected communities? In parentheses, thinking specifically about the lack of chloroprene emission standards on the part of EPA and DEQ, close parentheses. I might add to that is what my thought was a little along the same line, but maybe a little bit broader. We're talking about environmental class actions. And what about the environmental side of it? Whether it's a personal injury, continuing release issue to the air, whether it's a groundwater problem, and maybe some of the panelists can briefly describe in their class actions what positive was guaranteed and made an enforceable component of a class action settlement trial to eliminate the environmental risks to future people or the future of the area affected generally. Anybody want to take a shot at that?
Yeah, funny you should ask that question, because yes, we have a separate action for an injunction with regard to Denka DuPont. Interesting. Judge Feldman was the judge. He's no longer with us. He dismissed the claim against DuPont. Didn't think that was entirely correct. More about that later. But bottom line, let me start with this. Number one, the permit process is a bunch of malarkey. The permit process is a permit to pollute. One. Two, you'd think that if you invented a chemical, that you might be responsible for determining whether or not the chemical is on a fundamental level toxic, on a higher level, is it carcinogenic? In between, what's a safe concentration of the material over what period of time for people to breathe? And the answer is, well, DuPont doesn't do it, and Denka doesn't do it, and nobody else does it. So if somebody doesn't do it, it doesn't get done. Now, there's a bunch of statutes out there, I know, but the truth of it is, at the end of the day, right now, as we speak, Denka, and my worthy opponent is on the panel, and not on the panel, but he's one of the people in the room. They've taken the position that, yes, chloroprene causes cancer in rats, but the rat lung is nothing like the human lung. So we've been using rats for about, what, 50 years, 60 years now to ascertain whether or not certain chemicals are toxic, et cetera. Point I'm making to you is it's a giant hole in this whole process. And that is, in an ordinary product liability case, if you make the product, you're responsible for designing the product in a way that makes it safe. You have to anticipate unanticipated uses and so forth and so on. Not the case with chemicals. They go in there and they produce their own data. They persuade the governing authority, LDEQ, to give them a permit to dump. And in fact, the amount of materials that Denka can dump of chloroprene is in the millions and millions and millions of pounds, far in excess of the 0.2 micrograms per cubic meter, which is a tiny amount of material. So, good question, because in the past, over the past 40 years, we've never really ever, that I can remember, had any component that said, fix this.
Okay.
And James will probably back me. It's mostly money. You pay me money, you make me happy. But
Okay.
in this time, no, we're seeking an injunction, and the injunction is not simply to limit the exposure to 0.2. The injunction is to generally have the court control it in the same way they would control a prison, a professor, or that kind of thing. We'll see where it goes. It's never been done before, to my mind, it's one of those things that I hope we can succeed with.
Actually, I think that the mechanism, the procedural mechanism used for settlement in your public interest class actions is the consent decree, where
Right, exactly.
Right,
Exactly.
there is an order that says you shall do this, you shall do that. It's monitored by the court. Industry does not want that. They want the court out of the equation. But anyway, I'll just throw that out there because we're running out of time and have another good question.
And Bill, if I can,
Yeah, go ahead, Mike.
mention, in Arkema, we're doing three things. We have action for damages related to property diminution. We have an injunction to clean up the properties. And then we also have an injunction for medical monitoring to monitor under CERCLA. So we're doing three different things within that class action.
Excellent. Yeah.
Kind of like what Joe's doing. So
Yeah, you negotiate
degree.
a mandatory injunction in your settlement, and you use the consent decree to monitor the after litigation compliance. Okay, now this was a question, Michael Levy. Last night, Governor Edwards' keynote speech denied the fact of Cancer Alley's existence, claiming that the cancer rates in that corridor are no different from the cancer rates across Louisiana. What are your litigation strategy when it comes to fighting these kinds of misinformation campaigns? You can tell it's one of my students that
Yeah.
attempt to bias the justice process in favor of industry.
I don't want to monopolize, but again, look at the ProPublica article. You really have to look at that. It's not only, and by the way, it's not limited to Cancer Alley, it's all over the United States of America. The problem is we're talking about causing cancer and increased risk of cancer. At the moment, there is nothing out there that actually measures whether or not a particular chemical causes a person's particular cancer. We have something called, and that may seem like I'm not being honest, but the truth of it is the Louisiana Tumor Registry has been used by others to suggest that that's epidemiological evidence of the fact that there are not that many cancers. Well, that's not what the tumor registry is for. And if you look on the website, you read it, it says, this is not epidemiology, period. So what you have is you have increased risks based upon the rat studies that I just sort of alluded to. And so it may be true that, cancer, I don't know. I mean, the truth of it is, I think that there are higher numbers of cancers. The evidence seems to present that. And again, I would just, point you in the direction of this article. The article is based upon EPA studies over the past 50 some odd years. And if you want the site, email me or something, and I'll send you the article if you want. jbruno@brunobrunolow.com. Great article.
Okay. Great. I think we're out of time. Am I correct? We're out of time? Or do we have more time?
I mean, the next panel doesn't start until 3:25 if people want to stay. Just ask questions if the panelists are okay with it.
Yeah. Does anybody have any comments or anything? I mean, look, we can do this chat thing, but then I've got to interpret. I'd say, hey, look, raise your hand and speak out from the audience. Can the audience speak out?
Yeah, they can.
Yeah, we got 44 people in this panel. Listen to this. So somebody's got to have some thoughts, questions, or ideas. Sherry King raised a hand, I see. So maybe Sherry King, you have been acknowledged to provide any commentary or ask a question, whatever. Maybe Sherry doesn't want to or left the room. Anybody else have any thoughts or questions? Okay, let me throw one more out. And look, whoever doesn't want to stay cannot stay. But we're talking about class actions in Louisiana. To me, the biggest environmental, with all respect to my plant pollution, air pollution, physical injury brothers and sisters. I think our biggest environmental issue and crisis is our coastal zone. And so my question would be to the class action experts, and maybe we can have a plaintiff guy and a defense guy. Maybe the defense guy first, since plaintiff guys have been talking a lot. What do y'all think about the viability of the class action process to resolve the coastal litigations and, more importantly, our coastal environmental crisis?
Yeah,
Well,
Bill.
go ahead.
Well, Bill, I guess I would say it wouldn't surprise me if the oil industry enters into some type of a class action settlement. However, I think it would be really difficult and maybe they can get a class settlement like that certified. Sometimes it's a little bit easier to get a class settled so that the industry gets absolution than it is to actually prosecute a class action, because there's When you're dealing with the coast, you are dealing with a broad area, and you get into issues of questions of, you have numerosity, but then you get into typicality and commonality issues where I think the defense would make it very hard to certify a class action, just because you've got different operators doing different operations in different parts of the marshes causing damages. You have lease issues, you have all these diverse legal and factual issues that make it very difficult to certify a class. There is one area that I thought about a class action would be interesting. And
Can I go on that for just a second?
Yeah,
I
sure,
won't interrupt.
sure.
Okay.
Yeah.
But what, I mean, is there not a way for the defendants? I mean, the defendants got to want to get out of this crap, because they're never going to get out of it if they don't get out of it. That's like Yogi Berra, but nonetheless. So it seems to me that they would want to figure out a way to use a immunity bath class action type procedure to take care of everything without going bankrupt or whatever. I'm not saying they would, but that I mean, I guess we would need probably, could the defense bar with the plaintiff bar and the court agree to have a class action type settlement despite all of those numerosity, typicality, et cetera, impediments?
I mean, I think it's possible based, I mean, they kind of did it in the BP oil spill.
Right.
There were a lot of challenges of getting that class certified, but as far as the settlement, it went through. Right. And sometimes I use the BP class action settlement as an argument as to why a class should be certified. But the settlement class and actually getting a class action at the outset without a settlement, the standards are a little bit different. Okay. I think the oil companies certainly would want that. I'm not one of the lawyers litigating those cases.
But Mike, BP, forgive me.
Yeah. But it's different.
A joke of a case, an absolute joke of a case and it goes back to the nature of what the claim was. OPA was the basis of the right. BP thing. Okay. OPA was an extraordinarily powerful tool without which it never would have did. They would never have done what they did. OPA basically says, if Coast Guard walks up to your house and knocks on the door and says, you are responsible, you got to pay. And it's entirely up to you to start the process, to pay the money and so forth and so forth. There is no, and what's even more remarkable about it, there are no standards. James and I don't know, I've just disappeared from the Lou. Yeah, I don't see it anymore. But anyway, would say that insofar as the logic of how they came up with how much they were supposed to pay made no sense at all. I mean, I've never seen so much money thrown away in my entire life, and I've been in a lot of litigation over a lot of time. My problem with all this coastal stuff, with the toxic stuff, is that there is no motivation out there to persuade these people to do anything. You would think the oil companies would come forward, and someone told me once, I don't know if it was true or otherwise, it was tight with one of the big boys at Phillips, that they were interested, but it wanted on their terms. They were going to say how much money. They were going to dictate the process, and of course, and I get it. I would not be happy if someone told me, Joe, you've got to do A, B, C, D. All right, when otherwise there are no statutes, there's no law, there's no requirement that I do anything. Just like the old Trump scam. Well, I'm good at taxes because I don't pay them, because nobody's going to chase me for it. Well, that's the current mantra in our society today. Nobody's watching. So if nobody's watching, nobody's going to do anything. And that's why we have to come up with new and creative ways. My bitch about class action is not with defense counsel. I think I would never be angry at any lawyer on the other side that did what he had to do or she had to do to defend their client. I'm angry at the courts because most of them don't know what the hell to do. That's the problem. They're being poorly managed. Which creates the potential for abuse, and I'm getting on my high horse now, forgive me, but it is a huge problem. CAFA is a joke, and it could have been, and maybe the logic really was, and if you think about it, State court judges don't have enough wisdom to handle class action. Therefore, we're going to give it to the federal bench, which is appointed and vetted and is a meritocracy if you buy that. So anyway, I'll shut up.
And if I could say something about the judiciary, so I'm sorry, Jimmy had something to say. Go ahead.
Yeah,
Jimmy.
let me just,
Yeah, please do.
just interject, I guess, if you will, here, that although I think Joe points out a lot of things that I think can be improved upon. One, the direct question about the coastal issues. There are so many federal, state, and other and governmental bodies and so on involved. It's difficult for me to see how any real, if you will, plaintiff side of this could be a subject of a class action. I do agree with the idea that if there is a defense issue involved, that we could present as a settlement of a class, that would be much more, at least reasonable for some court to possibly look at and say. I also agree, if you look at the BP thing, that Joe is absolutely correct. Throwing $1 bazillion out there doesn't really do what in fact is needed to be done. But I don't think, the companies are looking at it obviously differently than certainly the plaintiff's bar would, and for that matter, even defense bar. But I do believe that there is a desire to resolve it. The issue is just what Mike and Joe were talking about, which is, the defendant may say, well, yeah, we'll resolve it, we'll do what we want. You take that and then everybody go home. That's not gonna happen. But there's gotta be a way. And if you want to fight with them, the problem is they can fight for as long as the government can fight. Okay. And that's to them. And look, that's maybe the only advantage that they have in these cases. And if they got to go to state court, if they ever did, particularly with a class action, they know exactly probably what's going to happen. Federal court, obviously, they feel like there's a lot better issue and chance for them to resolve it there than it is anywhere else. So look, I understand we all have the way we feel about how this is supposed to work and what's the best way to do it. And I agree with you, Bill. The first thing you really have to bring up is what are we going to do about what happened? That is, are we going to fix it? Is anybody going to, and as the settlements that I've done, part of the settlement was just as you pointed out, we came up with an agreement on how it was going to be resolved using one of the governmental agencies, EPA, DEQ, whoever it might have been, and end up with a procedure at least that everybody ultimately accepted. Now, plaintiff may say it should have been more and whatever. I understand all that, but you can't ever satisfy everybody.
And borrowing a line from the coastal seminar that I've had the pleasure of sitting in a couple of times, Chris Dalbin with the Tulane Institute, I think legislation, probably federal and state, ultimately would be needed to really have everything come together and fit nicely. Let me say something else. Somebody was talking about the courts, and the courts. I don't do class action. I've done a few in the past, but or with other people that did them. But the courts don't like environmental litigation because it's technical, it's complicated, and it's very, very time consuming. I mean, a little groundwater contamination case in Lafayette Parish takes up a lot of time by a judge who's got criminal docket, all this other stuff. So you've got that push back against it, that the courts don't have the time to handle environmental matters, and then you throw in a class action on top of that. It's like a double whammy, and so I think generally there's a reluctance, or at least certainly not an embracing of environmental litigation by some judges, because it's daunting and it takes all of their time, and so they kind of have that negative approach to it. And I think our jobs, both defense and plaintiff bar as litigators, is to try and lay things out fairly and honestly to the judge and help the judge reach decisions, point out that you can get a special master. A lot of them don't even know that, and there are ways to manage the process so that we can come up with a real remedy that protects the environment and the parties' financial interests. So
I would only say we're running out of time, Bill. That's all. I mean, we got to do it soon because we can only do so much. I can file stuff left and right, but it's just not, and it's creative, and I'm pretty creative, I gotta tell you, but still, you get somebody that looks at what I filed and go, what in the hell is this? So I don't know.
True.
Well, just keep reinventing the wheel, folks. I keep
All
trying
right.
to do it. I'm not saying I'm doing it, but I keep trying to do it. Okay, Judith, I think we're out of time.
Yeah.
Yes. Well, thank you guys all so much for coming. This was incredibly informative. Thank you all again. And excellent panel. I've learned so much. Thank you all.
Thank you.
All
Bye,
right.
everybody.
Thanks, Judith.
All
Bye.
right.
Bye,
See you,
everyone.
Bill. All right.